My name is Amber Widgery, and I'm a Policy Associate with NCSL's Criminal Justice Program. Thanks for joining us today to learn more about what states are doing to protect victims of domestic violence during the pretrial release process. In just the past 4 years, the majority of states have enacted new laws to protect victims of crime during the pretrial phase of the criminal justice process. That's the span of time between arrest and trial. In particular, these changes have been focused on victims of domestic violence. So why have so many states made changes to pretrial laws relating to victims of domestic violence, you may ask? Domestic violence is unfortunately really common. It is estimated that there are more than 12 million victims of such crimes every year, and that these estimates are low because many incidents go unreported. Most defendants who are arrested are eligible for pretrial release, with conditions of release set based on their risk of reoffending and their risk of failing to appear for court. Traditionally, this has meant that defendants who could post bail money were released, while those who could not remained in jail until trial. Bail amounts have also traditionally been set based on the class of crime that the defendant was charged with. Recent trends, however, in state pretrial policy have been aimed at protecting victims and also focusing the pretrial process on individual defendants. Individualizing the release process means that courts can consider more than just the class of crime when assessing a defendant's risk. 39 states have passed 116 new laws since 2012 that have changed release procedures to focus on defendants as individuals. From all of these new laws, 4 major trends have emerged. First, states have implemented risk-based assessments to help courts determine which defendants can safely be released into the community after their arrest. In the last 4 years, 26 new state laws have addressed risk assessments for all pretrial defendants generally. Research from the Laura and John Arnold Foundation has shown that risk assessments can reduce unnecessary detention of low-risk defendants while also enhancing victim and community safety. The Foundation's validated public safety assessment tool has now been implemented in more than 20 jurisdictions. In particular, defendants accused of domestic violence, stalking, violating a protection order, and other violent offenses pose a higher risk of endangering a victim or the community. So in addition to states that use risk assessments for all defendants, 5 states, Arizona, Colorado, Delaware, Illinois, and Maine, have all specifically authorized or required that courts use a risk assessment in domestic violence cases. Evaluating risk, in addition to other relevant factors, assists courts in making informed release decisions that protect victims and the community. These assessments help to identify high-risk offenders who may require special conditions or supervision, and those who should be detained until trial. Maine has even required law enforcement to adopt a process for the administration of a validated, evidence-based risk assessment that is specifically designed to assess the risk posed by domestic violence defendants, the results of which are transmitted to the bail commissioner and the district attorney for consideration when determining pretrial release. The second thing states have done is provide courts with additional guidance in cases involving particularly vulnerable victims. For example, legislatures in some states are requiring courts to consider specific factors in addition to the results of a risk assessment prior to determining release. For example, in the past 4 years, 6 states have required that courts specifically consider the safety of crime victims prior to releasing the defendant or setting pretrial release conditions. This particular factor was enshrined in Illinois' Constitution by a statewide vote in 2014, and in 2015, Nevada passed a joint resolution to amend their constitution as well. If this resolution is approved by the voters in the 2016 general election, the measure would require courts to consider the safety of victims and their families before determining the release of the defendant. Other factors legislatures have added for court consideration include risk assessments, a defendant's criminal history, whether a firearm or weapon was alleged to have been used during the crime, previous violations of release conditions, including protection orders, any threats of force, a history of substance abuse, and any evidence of controlling victim activity. The third thing legislatures have done to protect victims is provide judges with more tools to help monitor defendants who are determined to be low risk enough to be released into the community. This includes authorizing conditions and supervision methods that specifically focus on protecting victims. For example, many states have required or authorized courts to prohibit a defendant from possessing a firearm or other weapon while they're on pretrial supervision. Other conditions of release that have recently been authorized include sobriety requirements and compliance monitoring, electronic GPS monitoring with victim warning capabilities, domestic violence evaluation and counseling, and automatic entry of protection orders before release. States have also created additional criminal penalties for violating protection orders and related conditions ordered as a part of release. The fourth thing that lawmakers have done is authorize detention for high-risk defendants and provide for temporary detention until a risk level can be determined by a court. At least 31 states and the District of Columbia now require what is called a release hearing prior to releasing a defendant in cases involving violence. These hearings prevent an arrestee from bonding out prior to being seen by a court, who can then assess their suitability for release and also impose appropriate supervision and conditions of release. Several of these laws also provide for a holding or what is called a cooling off period before a defendant can be released into the community. For example, Mississippi has authorized judges to impose a holding period of up to 24 hours in instances of aggravated domestic violence or aggravated stalking. A few other states have authorized courts to deny release altogether under certain circumstances. Virginia has created a presumption that no condition or combination of conditions will reasonably assure the appearance of the defendant or the safety of the public if the offense involved includes strangulation and that the alleged victim is a family member or household member of the defendants. These four policy trends are aimed at helping to reduce the risk to victims in domestic violence cases, and legislatures will certainly continue working to improve the pretrial process in 2016. For more information about pretrial release, please visit our website by clicking the link below. Thanks for listening.